mahakama na tunatarajia kwamba huenda akatoa hukumu kumhusu kaimu inspekta mkuu wa polisi Gilbert Masengeli. Tumsikize.
Affidavit of service. However, there was neither appearance by any of the respondents or responses to the habeas corpus application. There had been no compliance with the orders either. That necessitated the court to violate orders in which it directed that on the morning of the 9th of September 2024, the Attorney General, the DPP, and the Director of Public and the Director of National Intelligence Service, the Inspector General of Police, and the Director of Criminal Investigations appeared through counsel. None of them had filed a response to the application, and the orders of the 29th of August are not being complied with. The Inspector General of Police, who the court had summoned, did not turn up either. The court postponed the matter to 3 p.m. for physical attendance of the Inspector General to explain why the habeas corpus orders are not being adhered to. The afternoon came and passed. The Inspector General of Police did not attend. The court was informed that he was out of office on official business, with the nature of business being revealed to be a workshop he was attending in Mombasa on budgeting that particular morning. In the afternoon, the court was told that he was engaged in security operational duties in coastal region. The matter was rescheduled to 5th of September 2024 at 10 a.m. as the court was keen to establish why the habeas corpus orders could not be executed in respect to the production before the court or the release of the second to fourth petitioners. Ms. Mwangi, who appeared for the Inspector General, explained as follows when pressed to explain the apparent persistent disregard of the court summons by the Inspector General of Police. The Inspector General of Police has not said he is not coming. He is requesting for another date because it is our position that the second to fourth petitioners are not with the police. The Inspector General of Police is requesting another date to appear because we had thought his officers would explain. The Inspector General is requesting another date to appear in court. And after holding some brief consultations, Ms. Mwangi saying the Inspector General of Police will come on Monday, 9th of September 2024. The officers of Inspector General of Police are here and have confirmed his availability on Monday, considering his work and duties, end of quote. The court, after this brief session, fixed the matter to 3 p.m. on the same day. Despite the court convening, the Inspector General did not show up. The court finally and reluctantly agreed to give the final opportunity to the Inspector General of Police to attend court, coinciding with the date the counsel for the Inspector General indicated he would be available. This was after she had made some brief consultations. The date was Monday, the 9th of September 2024. On that day, the court distressingly wrote, and I quote, "The stream of reasons and excuses by the Inspector General of Police are definitely bound to run out. To proceed at this juncture and history make a finding of contempt of court may be seen as premature in a grave matter of contempt of court, which is a form of criminal sanction, being an offense against the administration of justice. Our constitution requires a high threshold of criminal matters. Reluctantly, the reasons for non-attendance today must be considered. It is thus necessary that I postpone these proceedings to Monday, the 9th of September 2024. The Inspector General, having earlier indicated his availability on this particular day, should have no further excuse but to comply and attend the court physically at 10 a.m. so that the court can put this matter to an end. Due to the persistent non-compliance with both the court summons as well as failure to comply with the orders of 23rd of August 2024, the court opined that it was a case of contemptuous conduct that the Inspector General needed to punch even as he set the date for the 9th of September 2024. That date came and passed through. The Inspector General did not turn up, but he made last-minute attempt and sent his Deputy Inspector General in charge of Kenya Police to appear on his behalf. The court rejected the arrangement, noting that the open defiance of the court summons had metamorphosed to contemptuous conduct and was now a personal matter that had to be directly and specifically addressed by the person summoned. Following the failure to attend court or comply with the order of 23rd of August 2023, the court entered a finding of guilty for contempt of court against the Acting Inspector General of Police on the 9th of September 2024 and defined the sentence to Friday, the 13th of September 2024. The sentence. As part of considering the appropriate sentence, I want to look at this matter from a constitutional perspective. The preamble to the Constitution reflects the commitment of the people of Kenya to attain a number of aspirations. One of them is statement number 6 of the preamble, which states as follows: recognizing the aspirations of all Kenyans for a government based on essential values of human rights, equality, freedom, democracy, social justice, and the rule of law. The Constitution under Article 2, Sub-Article 1, proclaims itself as the supreme law of the land that binds all persons and all state organs. Article 3 obligates every person to respect, uphold, and defend the Constitution. It matters not whether they are mighty or low. The Constitution further proceeds to specify the national values and principles of national governance that bind all state organs and all persons whenever they make and implement public policy decisions, enact laws, and interpret. Among those values and principles are that contained in Article 10.2b, which as human rights, the rule of law, among others, whereas Article 10.2c as the principle of accountability. In matters of national security, Article 238 provides that the principles we shall apply and include the following: that national security is subject to the authority of the Constitution, and the national security shall be pursued in compliance with the law and with utmost respect for the rule of law, democracy, human rights, and fundamental freedoms. The rule of law principle is thus a common thread that the Constitution every demands in almost every function to ensure that every person is held accountable to the law. It ensures the equality of all before the law and prevents arbitrariness. The task of the court is to ensure there is a fair balance by applying the law when disputes arise either between the state and its citizens, or between citizens themselves, or between state organs or agencies. Neither a state organ or its officers or individual is above the reach of the law, as the Constitution in Article 2, Sub-Article 1 declares. The power of the court to adjudicate disputes according to the law is a delegation by the people pursuant to Article 159, which states that judicial authority is derived from the people and vests in and shall be exercised by courts and tribunals established by under the Constitution. The power is exercised subject only to the Constitution and the law, and is not subject to the control or direction of any person or authority by Article 60. The following excerpt from the South African Constitutional Court in the case of Secretary of Judicial Commission of Inquiry into allegations of state capture, corruption, and fraud in public sector, including organs of state versus Zuma and others, sums up the position of court orders in a constitutional democracy. The court held, orders and decisions issued by a court bind all persons to whom and organs of state to which they apply, and no person or organ of the state may interfere in any manner with the function of the courts. It follows from this that disobedience towards court orders or decisions risks rendering our courts impotent and judicial authority a mere mockery. The effectiveness of court orders or decisions is substantially determined by assurance that they will be enforced by all and sundry, including organs of state. In doing so, courts are not only giving effect to the rights of the successful litigant, but also, and more importantly, by acting as guardians of the Constitution, asserting their authority in public interest. End of quote. In the civil application, Dr. Fred Matiang'i, the Cabinet Secretary, Minister of Interior and Coordination of National Government versus Miguna and 4 others, the Court of Appeal, affirming the power to punish for contempt, held as follows. When courts issue orders, they do so not as suggestions or pleas to the persons at whom they are directed. Court orders issued ex cathedra are compulsive, peremptory, and expressly binding. It is not for any party, be he high or low, weak or mighty, and quite regardless of his status or standing in the society, to decide whether or not to obey, to choose which to obey and which to ignore, or to negotiate the manner of his compliance. This court, as must all courts, will deal firmly and decisively with any party who deigns to disobey court orders, and will do so only to preserve its own authority and the dignity, but most to ensure and demonstrate that the constitutional edicts of equality under the law and the upholding of the rule of law are not mere platitudes but present realities. End of quote. The court entered a finding of guilty. This court entered a finding of guilty on the 9th of September 2004 after all efforts afforded to the contender to purge the contempt were ignored. This was to ensure its authority and dignity, which it is exercised on behalf of the public, does not get annihilated, leading to a situation of impunity and anarchy. The Supreme Court, in Igithiga and 5 others versus Kiriko Tea Factory Company Limited, acknowledged that courts have inherent power to punish for contempt, to vindicate their authority, besides pinpointing the source of authority of Kenyan courts to punish for contempt after declaration of unconstitutionality of the Contempt of Act 2016. The court stated, and I quote, courts possess the inherent power to enforce compliance with their lawful orders through sanctions imposed through contempt of court. We note that the Contempt of Court Act, having been declared unconstitutional in Kenya, Human Rights Commission versus Attorney General and another, 2018 EKLR, on November 9, 2018, the instructive provision remains Section 5, subsection 1 of the Judicature Act, which grants the High Court and the Court of Appeal the power to punish for contempt. It provides the High Court and the Court of Appeal shall have the same power to punish for contempt of court as for the time being possessed by High Court of Justice in England, and that power shall be extended to upholding the authority and the dignity of subordinate courts, end of quote. Today, this court is required to pass sentence for contempt of court. The principles to be considered in determining an effective sentence in a contempt of court matter were considered by the South African Constitutional Court in Jacob Zuma case, where the court discussed the coercive versus punitive order and explained the difference between the two approaches as follows. There is a distinction between coercive and punitive orders, which differences are marked and important. A coercive order gives the respondent the opportunity to avoid imprisonment by complying with the original order and desisting from the offensive conduct. Such an order is made primarily to ensure the effectiveness of the original order by bringing about compliance. A final characteristic is that it only incidentally vindicates the authority of the court that has been disobeyed. Conversely, the following are the characteristics of a punitive order. A sentence of imprisonment cannot be avoided by any action on the part of the respondent to comply with the original order. The sentence is unsuspended. It is related both to the seriousness of the default and the contumacy of the respondent, and the order is influenced by the need to assert the authority and the dignity of the court to set an example to others, end of quote. The court then went ahead and found that the conduct of the contemnor, Mr. Zuma, had made it undesirable to benefit from coercive order, reasoning as follows. A coercive order would be both futile and inappropriate in these circumstances. Coercive committal, through a suspended sentence, uses threat of imprisonment to compel compliance. Yet, it is incontrovertible that Mr. Zuma has no intention of attending the commission, having repeatedly reiterated that he would rather be committed to imprisonment than cooperate with the commission or comply with the order of this court. Accordingly, a suspended sentence, being a coercive order, would yield nothing, end of quote. The contemnor, in this case, was accorded every opportunity to punch the contempt to the extent that attending a workshop in Mombasa was more important than obeying a court summons intended to seek an explanation on the whereabouts of the second to the petitioners, last seen on the 19th of August 2024, the date of alleged abduction. Nevertheless, I took note that on the last date, the contemnor attempted to bring in his deputy to explain the position with regard to the summons. The deliberate defiance of court orders brings impunity, particularly when it is done by those entrusted with public power, as it is inconsistent with the purposes and the objects of the Constitution. In passing this sentence, I am conscious that it is directed to the highest ranked police officer in this country. He is still in office. That might pose a challenge in the enforcement of the order, since in police service, seniority is highly regarded. That, however, cannot deter me from pursuing and standing firm in the defense of the aspirations of Kenyan people who decided at the time of enacting this constitution to have a country that is governed by adherence to the rule of law. Part of the oath of office that I took as a judge states as follows: I will at all times and to the best of my knowledge and ability protect, administer, and defend this constitution with a view to upholding the dignity and the respect for the judiciary and the judicial system of Kenya, end of quote. The constitution of this country is supreme, and Article 2.1 reiterates that by stating that it binds all persons and all state organs. No man or state organ or authority is above the Constitution. The Constitution command through this court is that I uphold the rule of law by protecting the integrity of the judicial system. The significance of this sentence today is to vindicate the cherished principle of the rule of law in our constitutional democracy by restoring the dignity and the authority of this court in public interest. Borrowing from the South African Constitutional Division, the contemnor shall serve sentence as follows. The contemnor, Mr. Gilbert Masengeli, is sentenced to 6 months imprisonment. Mr. Masengeli is ordered to submit himself to the Commissioner General of Kenya Prisons to ensure that he is to be committed to a prison facility to commence serving sentence of the imprisonment imposed. In the event that he does not submit himself to the Commissioner General of Prison Service as ordered, the Cabinet Secretary for the National Interior must take all steps that are necessary and permissible in law to ensure Mr. Gilbert Masengeli is committed to prison to commence serving the sentence imposed on him. The court, nevertheless, finds it desirable to impose this sentence as a coercive order as opposed to a punitive order. In that regard, Mr. Masengeli may avoid serving this sentence, and therefore, in that regard, the court shall suspend this sentence for 7 days only. The acting Inspector General of Police can redeem himself and comply by availing himself before this court in person to answer to the issues he has been avoiding. In default, the sentence shall automatically become effective.
From the law side of Kenya.
Yes, just
from the law side of Kenya, we for the law society, my lord, we just want to say thank you.
Okay, just a minute, Mr. I will hear you. Yes, Mr. Your name?
From the law society of Kenya, my lord, we thank you for the whole ruling. We also are cognizant of the second, third, and fourth petitioners, Mr. Bob Jagi, Jamil Longton, and Aslam Longton. They are still permanently prejudiced. There is a duty, my lord, on the first defendant the first respondent to uphold, administer, and defend the Constitution, and any abrogation of that duty transfers an obligation to invoke the supremacy of the people of Kenya my lord. When we come to the issue of stay, it is an equitable remedy to those who come to the court.
Okay, has it been made?
It has not been made. I do not think I will have an opportunity to address you that because my senior President Harvey. From the Law Society of Kenya, we are still very concerned about the whereabouts of the second, third, and fourth petition. And even as we embrace your ruling, my Lord, we pray that the court makes a focus in the application as well as the petition, so as to get to the bottom on the safety, the whereabouts, and the personal presentation of the petition before the court. My Lord, I want to rest there and thank the court profusely for the ruling. Thank you so much, my Lord. May I proceed?
Yes, go ahead.
My Lord, prior to the reading of the sentence, Mr. Bitter and I tried to address the court on a procedural issue were not given that opportunity. And the issue at hand, my Lord, was the issue of mitigation prior to sentencing. My Lord, now that that procedural step has been denied the first respondent, we're now applying that our application be heard this afternoon or latest by tomorrow, bearing in mind that you have suspended the sentence for 7 days. Or latest, sorry, Monday. Today or latest Monday. My Lord, any date after 7 days for our application for hearing would be flying in the face of Article 25. And you have condemned the Inspector General of Police to a 6-month sentence without his application having been heard, without him having extinguished his rights that are guaranteed under the Constitution. And therefore, it is our humble prayer that the directions given on our application be for hearing inter partes either this afternoon or on Monday. That's all.
Proceed, Mr. Ward.
Yes, with the permission of Malawi Senior, I think we just to make a small adjustment. It will make sense if the applicant sought leave, and if leave was granted, to amend prayer 3 in that application. Prayer 3 sought to suspend the sentence pending the hearing of the application. We don't need to amend it to align it with the ruling that has been given by the Honorable Court. So we seek leave, my Lord, to write on that. Number 2, which is a housekeeping issue. It would make sense, my Lord, that as we set the application, today's application for hearing, we hear it together with the petitioner's application that has been pending. I say that, my Lord, because it not only works for the LSTA, Mr. President, it also works for the first respondent who has been required by this Honorable Court to give an explanation. And that explanation will have the purpose and effect answering the application dated 22nd August 2024. But the Lord's such okay. In terms of final directions, we will pray that on our application, we serve our written submissions by end of day tomorrow, by Monday. We do have the draft form, but we could serve, we could file and serve.
Written submissions by which date?
Monday. Oh, the close of business today. They should be ready. We file our written submissions from the application and serve by close of business today. And with the permission of the court, we take directions on the LSK application so we can respond to both applications. And maybe I join my learned senior, Nina, on a priority hearing cases within the 7-day window. Thank you.
Yes, my Lord, I support what they say because there are two pending applications, my Lord. I'm praying for the court to give directions on those two pending applications. Because, my Lord, you realize that the sentencing does not bring a closure to the petition. And in terms of priority, my Lord, I believe the application by the first respondent or its nature should be given priority in terms of the directions that you are issuing. Yes, my Lord, and I also wish to be on record, my Lord. I'm kindly requesting the court to be on record that I sought to bring to the attention of the court that there is a constitutional requirement for a party to meet before sentencing, as set out by the Supreme Court in the decision of Francis and another versus Republic, EKLR 2017. Thank you, Lord.
Set out in the case of?
Francis Muratetu and another versus Republic. 2017, EKLR, Supreme Court. Thank you, Lord.
My Lord, it's been a heavy day. I don't think we need to burden ourselves with many more complex issues. You can retreat and give directions to the hearing of the application by first respondent. I think the only prudent course will be for us to give sufficient time to reply to it. A day or two will not be good time. We will have 7 days. We put a substantive reply. Lord, to give us a mentioned day where we can come and have that communication in the directions. We have to see this.
My Lord, in addition to that, we are kindly requesting the court, Ms. Omega, for the petition. We are kindly requesting the court that our application be had by retreat from there as my Lord.
My Lord, before that, my name is Ramadan Ibaka. There was a prayer that was made on the issue to amend the application where they attempted to amend the same orally. It is our view that if indeed they intend to amend, perhaps they can serve us with the amended application at close of business today. Then we can put in our response to the same within the same 7 days. So we are opposed to the oral amendments.
Well, I think we are all agreeable, speaking the same language. At the very minimum, the court has directed that within 7 days, the first respondent who are here, we will comply. So, in between, we can take whatever directions the court wants to fashion. We thought some of those proposals worked for the first petitioner.
So are you able to amend your application?
We are happy to amend by close of business today. We are happy to file our written submissions. It's up to us. And we are happy to comply with all directions. Whichever direction the court gives in respect to the LSK application, you want to delay it, that's up to them.
The LSK application is dated 23rd of August. Ms. Omwenga.
Madam, permit me to simply go.
All right. Mr. Munga, your application is dated when? And the one for the first respondent is dated 12.
Our application is dated 22nd, not 25, 22nd.
Next week we have a bench hearing the entire week, so I will not be available.
I take the following. My Lord, I take note of what the court has said, that has been totally prejudicial.
Yeah, but now, you see, when we sit as 3 judges, I cannot be the one to tell them you can't sit. It will not be right, and I'm the junior most. Out of that bench, I'm the junior judge.
Then perhaps maybe you can send us to another judge hearing of our application.
Yes, no problem. Can I refer the matter to the PJ, the presiding judge?
Yes, please.
Which bench matter is that? Just
We have 3 of them. We have 195, 22, and the commercial bench.
Yes, Smita is sitting.
He's sitting next week.
Okay, I think in that case, because of the urgency of the matter, I can refer you to the presiding judge. The presiding judge can.
I sense a big problem. Yeah. My reading of the law.
Yeah.
At this moment doesn't seem to combine the idea of referring this application for another judge, because we'll be amending to ask that this sentence be set aside. I think.
They can set it aside. There is no problem if they find merit in it.
No, but it should be difficult, because if you are around, the procedure says you can't send this matter.
But you see, I am around, but I'm not available because we have 3 benches next week.
Yes,
3 benches next week,
yes,
and in those 3 benches, I'm in all of them.
Yes.
In those 3 benches, out of all the judges in those benches, I'm the junior judge, so I cannot be the one to ask them to adjourn. So I'll have to comply with what they are saying.
The difficulty is,
and I cannot, you see, a bench matter involves many parties and many advocates.
Aya, mtazamaji, umesikiza ni uamuzi ama amri ya mahakama ambayo ilitarajiwa kutolewa asubuhi ya leo kumhusu kaimu Inspector General wa polisi Gilbert Masengeli kwa kwenda kinyume na amri za mahakama. Jaji Lawrence Mugambi akifafanua sheria inavyosema, akisema kwamba hakuna yeyote aliye juu ama ambaye ana mamlaka zaidi ya sheria ambayo ni katiba, akisema kwamba hakuna yeyote ambaye hawezi kuchukuliwa hatua za kisheria bila kujali vigezo vyovyote, iwe ni vyeo na kadhalika, akisema kila mmoja anaweza kuhukumiwa kwa mujibu wa sheria. Hata katika kutekeleza usalama wa taifa hauwezi kwenda kukiuka maagizo yaliyowekwa chini ya katiba na kumhukumu kifungo cha miezi 6 gerezani, akisema ndio anaelewa cheo anachokishikilia sasa hivi utekelezaji huenda ukawa ni changamoto, lakini akamhukumu kifungo cha miezi 6 gerezani, akisema ajisalimishe kwa mkurugenzi wa idara ya magereza aweze kuhukumiwa na kutumikia kifungo hicho, la sivyo waziri wa usalama wa taifa ingilie kati kuhakikisha kwamba anatumikia kifungo hicho. Lakini awali akafafanua kuna njia mbili za kutekeleza amri hiyo, akitoa mfano wa hukumu iliyotolewa na gereza na mahakama nchini Afrika Kusini, akisema kuna ile inaitwa coercive na punitive order. Akaamua kwamba kwenda na ile coercive, ile ya kutoshurutisha, na ndiposa akampa siku 7 kujiwasilisha mahakamani wapo hataki kutumikia kifungo hicho. Akampa siku 7 kujiredeem. Na wageni wetu wako hapa studioni wamekuwa wakifuatilia kwamba jisalimisha, jiwasilishe yeye mwenyewe mahakamani. Awali alikuwa amemtuma mdogo wake na kadhalika, lakini sasa mahakama imemtaka ajiwasilishe yeye mwenyewe wapo hataki kutumikia kifungo hicho. Na wale mawakili pale tumeona makamu wa rais wa LSK Mwaura Kabata akitoa wasiwasi wake kwamba bado